This is Dr. David Schein, and welcome to Business Law 101. How do we get personal property? Well, most of us buy it. We can acquire it by gift, or we can inherit it through a will. Now, the most common gift is an inter vivos gift, and that means during life. Vivos, and you might think of the word vitality. A person is vivacious, or a person has a lot of vitality. Base word vivos from the Latin. So during life. And it's a voluntary gift. The donor is the party making the gift. The donee is the party receiving the property. These are pretty easy definitions here. Now, keep in mind, to have something and keep it, it has to be a completed gift. And the problem is when we look at this stuff in terms of inter vivos gift, we move to a second issue, which is called gifts in causa mortis. Now, I'll tell you, folks, causa mortis is in every business law textbook for completion. I have never seen a case that fits causa mortis. And here's the scenario. You have an uncle that you're close to. The uncle is dying of cancer. So he says, I'm going to give you my 1965 Corvette Stingray collector car. Probably worth $200,000 if it's in good condition today. And so it's one of the things to think about. But suppose that your uncle says to you, you know, I've just found out that I have leukemia, and I am going to give you my 2018 Dodge Ram pickup truck because you're my favorite nephew, and, you know, I'm going to give you this terrific truck because I'm dying. Obviously, I can't take it to the grave with me. Well, leukemia is a largely treatable disease today. And so the uncle goes to MD Anderson, gets some good treatment, is going to survive, at least survive now, and doesn't need the car. Used to not anticipate needing the car, but then he goes to MD Anderson, they help him get cured, and he comes back to the nephew and he says, hey, guess what? I've got an effective treatment. I'm going to take the truck back. And he is entitled to do that under causa mortis, because unless he dies for the reason that he anticipated, the gift is no longer binding on him. So it's a very strange set of circumstances.
What if you sold the vehicle before he recovered? He gave it to you. Yeah. And then that interim, you know, you can do whatever you want with that gift. Mm-hmm.
So well, I would say that under the concept of gifts in causa mortis, he would have a legal claim on the proceeds from the sale of the truck. But again, I've been doing this a long time, and I have never encountered a gift in causa mortis, at least one that was revoked. And, you know, so, I mean, it's an interesting thing to chat about, but it's not, you know, realistically, it doesn't do much. And I'm thinking of just not including it in the course because it's so, I mean, I've been practicing law 42 years. I've never come across it. I don't think it's something I think the textbooks like to throw in there to make them look important, but or to be comprehensive, but it just isn't something that's very realistic. You know, and I've seen, you know, all sorts of stuff happen. My grandmother, when she went to the rest home, she gave away her car to one of her favorite grandchildren. Yeah. So, but she passed away. So, I mean, it was pretty straightforward. That was, we had to take the car away from her because she was such a dangerous driver toward the end. We literally had to take keys away from her. Abandoned property is like you put out on the curb. Sometimes you'll see usable stuff on the curb next to the trash cans. That is abandoned property. It's for anyone to take. Lost property, on the other hand, is very typical. You know, it's a rainy day. You go to a concert or you go to a meeting or out to dinner. You leave your umbrella by the front door. When you're leaving, it's not raining. You don't take your umbrella. You have lost it. It still belongs to you. And then mislaid property, which is when it's is very similar lost property, title still stays with the original owner.